Hey, Angela Langlotz, trademark and business law attorney here with another episode of Trademark Wars. People really love these, so I thought I would do another episode of Trademark Wars. Everybody loves a good trademark kerfuffle. In today's version or episode of Trademark Wars, we're going to talk about Tinder suing Bumble. Yes, it appears that romantic app rivals Tinder and Bumble are in a trademark kerfuffle. So what's being alleged? Well, Tinder is alleging, among other things, patent infringement, trade secret theft, and trademark infringement. Now today, that's a whole lot of stuff to talk about. So today, I'm just going to talk about the trademark infringement issue. If y'all want me to talk about the other two issues, then leave a comment on this video and I will do that. So let's dive right in. Now, Tinder owns the mark Swipe for dating apps, and it acquired this mark from another company who created a dating app called Swipe. So the interesting thing about this is that because of the way Tinder acquired the mark from another company who already had the trademark registration, they never had to prove that they were using the mark in commerce. Now, this is kind of interesting. So normally, when you apply to register a trademark, you have to prove to the trademark examiner that you are using the mark in commerce. And this is really important because you don't have trademark rights unless and until you actually use the mark in commerce. And use in trademark land means something different than it means to us in the rest of the world. So Tinder never had to do that, right? Because they acquired this mark from someone else who already had the registration. I suspect, but I can't prove because I wasn't privy to the negotiations, that there was some trademark bullying going on the part of Tinder to acquire this mark from this other company. So their use, Tinder's use, was never examined, right? Never examined. And so that's one thing, right? So there's this use issue, and I want to go show you. The use in a second. Actually, no. Let's just dive right in. I'll show you how they're using it. I don't think that their use, right, use in the rest of the world qualifies as use under the Lanham Act, right? That Lanham Act is the trademark law. So let's go have a look. I'm going to switch you over here. Let's see. Let me switch so you can see my screen. There we are. Okay. So here's how Tinder is using it. And remember, trademarks are adjectives and not nouns and not verbs, right? So it's a Swipe brand app. That's how you have to use it if you're claiming use under the trademark law. Now, in this instance, Tinder is not using the word swipe as an adjective at all. What their web page says is swipe right. They're using swipe as a verb, right? Swipe right to like someone or swipe left to pass, okay? So they're not using this, in my opinion, as a trademark. And let's look at Bumble. Tinder is alleging that Bumble is infringing and using their trademark. I don't think that's the case because Bumble isn't using this as a trademark either. They are saying, let me see, where do I find it here? A match is created after two users have mutually right swiped. So they are also using the term swipe as a verb and not as an adjective. So I don't think, in my opinion, there's any trademark use going on here at all, neither from the plaintiff nor from the defendant. What else is going on here? Let's talk about genericism, right? We talked about how if the term describes a quality of the goods or services, it's not capable of functioning as a trademark just by virtue of that. So the word swipe describes a gesture that you do with your finger, and that's part of how the app works, right? So if we're swiping on the app, that really describes a functional part of the app or a use of the app. I don't think that the word swipe is capable in this context of functioning as a trademark. So I think there are a whole bunch of issues going on here, and the court is going to have to sort all of this out. So it should be interesting to see what happens, and when the court decides, if there's a decision, the parties may settle out of court. Who knows? An additional wrinkle to this too, interestingly enough, is that Match.com was in talks with Bumble about an acquisition of Bumble. And one of the things that Bumble is alleging in their countersuit, right? So Match sued and now Bumble is countersuing, is that Match is using information gleaned in those acquisition negotiations in order to forward their trademark and trade secret and patent infringement claims. So there's a whole bunch of stuff going on here. Bumble has alleged that the only reason why Match is doing this is to lower the value of Bumble so that they can get a better price for Bumble. I could totally see them doing that. Anyway, we'll see what happens. So I'm Angela Langlotz. I go live here every day to talk about intellectual property issues, and you can find me online at TrademarkDoctor.net. If you like my Facebook page, which can be found at facebook.com/TrademarkDoctor, you'll be notified each and every time I go live. And if you have questions about trademarks, patents, or copyrights, let me know there by leaving me a message, and I will answer your question in a future live and tag you so that you know I have responded to your question. I will see everybody tomorrow, and have a great day.